Thank you. My name is Nicola Allsop and I'm a barrister at Quadrant Chambers. I've practiced in commercial law for over 15 years and I specialise in civil fraud, insolvency and banking litigation. The title of this QBiT talk is, What is the fraud exception? In the 10 minutes available, I'm going to answer 3 questions. First, what is the fraud exception? Second, when can it be relied upon? And third, how can it be invoked in an application for an injunction against a bank? So moving to the first question, what is the fraud exception? It is the exception to the very strict rule that a bank who issues a letter of credit or performance bond must pay out upon the presentation of compliant documents. Now that strict rule is known as the autonomy principle. The letter of credit or performance bond exists separately to and is autonomous from the underlying contract. So let me give you a common example. The buyer of goods is required to provide the seller with a letter of credit issued by the buyer's bank, the issuing bank. And the letter of credit is the bank's guarantee that it will pay the seller, the beneficiary, against the presentation of specified documents. So as long as a valid demand is made on the letter of credit, the beneficiary is entitled to the sum demanded and the bank is bound to pay. So in that sense, the bank's obligation to pay is separate and independent from the underlying contract between the buyer and seller. And in practice, it means the bank pays strictly in accordance with the letter of credit and is not concerned with any allegation of breach of contract or dispute over the sale of goods pursuant to the underlying contract. It's difficult to overstate the importance of the autonomy principle. It is described, often in cases, as the lifeblood of commerce. The fraud exception is the only true exception to the autonomy principle. The bank need not pay out further to a valid demand made on the letter of credit or guarantee when the fraud exception is satisfied. The fraud may relate to the documents presented to the bank, for example, if they have been forged, or if the beneficiary had no honest belief in the validity of its demand. And this leads us neatly onto the second question. When can the fraud exception be relied upon? And the simple answer to that question is rarely, because it's very difficult to invoke. Well, let's unpack that a bit. The circumstances in which it can be said that a beneficiary, that's the seller in our example, can be said to have no honest belief in the validity of the demand. The court will restrain the bank from paying out on a letter of credit or bond where it is seriously arguable that on the material available, the only realistic inference was that the beneficiary could not have honestly believed in the validity of its demand and the bank was aware of such fraud. And 5 points flow from this. First, evidence of established fraud is not to be confused with an allegation of fraud, and the latter is not going to be sufficient to fulfil the fraud exception. Secondly, there must be clear evidence of established fraud given the requirement that on the material available, the only realistic inference is that the beneficiary could not have honestly believed in the validity of its demand. And clear in this context means strong corroborative evidence. Thirdly, the requirement for strong evidence normally means that having been given an opportunity to answer the allegation, the beneficiary has failed to provide a satisfactory explanation where one could properly be expected. Fourth, the bank must be aware of the established fraud, but the bank's not under an obligation to carry out an investigation. The onus isn't on the bank to examine the merits of the buyer and the seller's respective positions and decide which one is well-founded. The bank is not the judge. The fifth and final point, the practical consequence of all this is that a bank will, in almost all cases, be bound to pay and cannot be enjoined from so doing because the bank will simply not know or be required to investigate whether a demand is honest or not. So turning now to the third and final question as to how the fraud exception can be invoked if you find yourself in a situation where there is strong evidence of established fraud. The fraud exception will be relevant in several contexts. For example, it may provide the bank with a defence to a seller's action for payment out. It will also fall to be considered in the context of the bank's right to an indemnity against its customer. But I'm not going to focus on those situations. Rather, I'm going to look at the circumstances in which an interim injunction can be obtained, restraining the bank from paying out on a demand made pursuant to a letter of credit or on-demand bond. So who are the parties to that application? Well, the applicant is likely to be the buyer, as the entity ultimately bearing the loss. The respondent will be the bank. And if the respondent is the bank, the application is for an injunction restraining payment by the bank. The beneficiary, that's the seller in our example, may also be named as a respondent, in which case the application is for an injunction restraining presentation of documents or making a demand or restraining receipt of payment. As we've seen, the applicant must demonstrate that the case is one of established fraud of which the bank is aware. And that's a significant hurdle in terms of the nature of the evidence that the court requires. But cogent evidence of established fraud is not enough. In addition, the applicant must demonstrate that the balance of convenience favours the grant of an injunction. And the competing factors in this regard are, on one hand, the harm to the beneficiary in preventing the bank from paying, versus, on the other hand, the harm to the applicant in allowing the bank to pay. That's obviously a fact-sensitive inquiry, but the reported decisions demonstrate that extraordinary facts are needed to tip the balance of convenience in favour of granting an injunction against the bank. The hurdle is rarely overcome because either it will be found at a later stage that there is no cause of action against the bank, in which case the applicant has no right to a remedy, or if there is a cause of action against the bank is likely to be good for the damages. There are only a couple of reported decisions in which the court has found that the balance of convenience favoured the grant of an injunction. In one of those, at the ex parte stage at least, this was because the court accepted the applicant's evidence that payment out would lead to the debiting of the applicant's bank account, leading to its immediate insolvency. The court found that the balance of convenience was satisfied on that basis. But the injunction was not continued at the return date hearing because the court determined that the applicant had not met its duty of full and frank disclosure. Accordingly, the balance of convenience will be an insuperable difficulty in almost all applications for injunctive relief against a bank, and the bank will rarely, in practice, be enjoined from paying out. And that is the fraud exception.